Obviously, we need to make sure that our courtrooms are accessible to victims with disabilities. They have to be wheelchair accessible. They have to be made accessible in terms of the abilities for victims to vocalize if they have a difficulty speaking. We have to make sure that there's sign language interpreters if individuals cannot hear, so that not only they but everyone else in the courtroom can understand what they're trying to convey. We often, in cases involving persons with disabilities, will request the judges involved overseeing the case to give us an opportunity to address these witnesses in a little bit different way than we normally would. Sometimes we ask to have them brought down from behind the witness stand where it can be a little intimidating, and maybe just sit at a table with the attorneys sitting there and kind of having a conversation, which is maybe a little easier and less intimidating than sitting behind a big desk or chair. And we can also request the court, and we are granted the opportunity to question these witnesses in a different way. For example, you normally cannot use a leading question if you're a prosecutor and asking questions of your witnesses, but in connection with persons with disabilities who have a little more trouble conveying what happened to them, we are allowed to use leading questions, again, to try to bring that story out about what occurred and how it happened. So we do a lot of different things and special things to try to accommodate the needs of victims with disabilities in the courtroom today. And that's a great thing because 25, 30 years ago, this simply wasn't done. And 25 and 30 years ago, these cases simply weren't coming forward, and there was no justice being obtained in these cases. And we're doing that far more often today than we have in the past, and that's a wonderful thing.